The next case to come before the court is Chemical Bank versus Howard Capone et al. This is case 19CA0079M. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do wish to reserve rebuttal time, let me know before you begin your argument, and I'll do my best to keep you apprised of the time. These arguments are being visually and audibly recorded, as well as being live streamed. We have read your briefs and we are ready to proceed when you are. Mr. McGookie, you're first.
Thank you, Your Honor. Dan McGookie here on behalf of the appellant, Howard Capone. I would like to reserve 5 minutes of my time, Your Honor, if I may.
All right, thank you.
Thank you. This case, Your Honors, I would suggest to you that it presents some intellectually challenging issues and kind of almost law school sort of stuff, but interesting, very interesting nonetheless. The facts, I think, are pretty much, not largely, I think totally undisputed. Howard Capone lived at the residence, which is the subject of this foreclosure action. He has lived there for a number of years, and he had lived there with his living girlfriend, Valerie. I'll just call her Valerie. Howard, although he is able to speak like I am to you right now, he suffered an injury that all part in his affidavit, and anything I'm about to say isn't documented in the records. In the record, Your Honor, it's in the trial briefs with the proper references to the record. He resided at the residence. He made his mortgage payments on time. And then on a day, I believe it was in 2017, for the first time, he had a sheriff's deputy knock at his door with a writ of summons. And until that point in time, he had no idea whatsoever that a foreclosure had even been filed against him, much less the foreclosure being filed, having gone to sale, and a deed being transferred to Chemical Bank, the plaintiff, purchaser at the foreclosure sale. So he was completely stunned by that. And as it
Counsel,
yes.
Could I interrupt for just a second, because I want to make sure I'm clear as to what's what the history is here, the correct history. When you say he made his mortgage payments timely, he did not actually send them in, but he gave money to his living girlfriend, right?
Right.
Okay. So
thank you for the correction, Your Honor.
I just wonder, because that's not necessarily making them timely. If you just give them to somebody else and they don't make them, you're still responsible for them, right?
Exactly, Your Honor. I would not suggest otherwise. Maybe I could have used better language there.
And the other question I'm sorry I have for you really quickly is in regard to the brain damage. He is not under any type of guardianship or anything, is he?
No.
Thank you.
No, he's not. No. To correct myself there, Your Honor, I appreciate the point that you make. He gave every payment to his girlfriend, and this is attested to in his affidavit. And unfortunately, his girlfriend had taken the money and used it for some other purpose, and so the payments, in fact, were not made. Were not received by Chemical Bank. But what I do believe is important here is not only was he deceived by his girlfriend and the fact that she was not making his payments, but then to add maybe insult to injury, she was the one who had received and signed for service, not only on behalf of Howard, but on behalf of his parents, Robert and Myra, residents of Michigan. And again, everything's documented in the record here. So and then she went so far as to file an answer on Howard's behalf, signing his name to an answer. So as far as the court knew, I mean, we're certainly not pointing the finger at the court at all. As far as the court knew, there was proper service. There was even an entry of appearance by way of an answer. And then there was a total disappearance because the court, as we appreciate its efforts in these foreclosure cases to mediate see, they set up a mediation. Of course, the defendants, certainly Howard didn't show, no one showed, because no one other than Valerie even knew of the case. So those are the undisputed facts of this case. Now, turning to the issues, there's basically two, and then there's a couple of sub-issues that Mr. Dighton has raised, which I want to address as well. First issue, and the court made its ruling that we filed again. I came in after the fact, after the property was even sold at foreclosure. And of course, like I just said, that's when Howard Capone learned of that he was even in foreclosure, much less had his property already sold. That's when I was contacted, and then we immediately filed within days a motion for to vacate the judgment based on jurisdiction and for relief from judgment, which I believe is kind of superfluous at this point, because I think we can all agree that a motion to vacate is the proper procedure if, in fact, the court lacks personal jurisdiction. So it's not even a motion for relief from judgment under Rule 60, but a proper motion to vacate. And we can all agree that that if, in fact, personal service has not been obtained upon a defendant, then the judgment is void ab initio. I don't think anyone's arguing that basic point as well. Now, as far as the service goes, there's two issues here, basically. Service and standing. I'd like to address, as the court did. The court said, we got service. The facts show that that every defendant, and particularly Myra Capone, that's who we're focusing our argument on here. That's the Howard's mother, resident of Michigan. The court said, well, she was properly served at the residence in Ohio, in Medina County. That, without a question, is wrong. Based on the affidavits, Myra never lived at the residence. She was not there at the time the service was made. In fact, it was Valerie who signed her name. So those are the undisputed facts. And under Civil Rule, I believe it's 4, service is proper if there's service at the residence of the named defendant. So this.
Counsel, what does that have to do with your client?
Yeah.
Because I can see that maybe she could come in and file a 60, or not even a 60B if you're right, a motion to vacate, and she couldn't have a judgment against her that she would be responsible. But why does that have any impact on your client?
Well, that jumps right into the second issue of the case, and that is standing. Again, I want to point back I'll come to answer your question, Your Honor, but just to kind of finish up on the service issue. Contrary to what the court said, I don't think this is beyond any realistic doubt. Contrary to what the court said, there was not proper service. You don't reach the level of a presumption of having proper service unless there's service made upon at the residence of the defendant. That's right in the rule. And since service was not made at Myra's residence, which was in Michigan, there's no presumption. So the presumption of service never arises. So the trial court erred in that regard. Now, the second issue is
let me ask, counsel, excuse me, as to the service question then with Myra, how was the bank or mortgager or anyone to know that the residence was Michigan?
Well, just, Your Honor, I would respectfully suggest that just like in any case, I've been practicing law for 41 years, and sometimes my clients walk in the door and they have a lawsuit that they need to file, and we have to do the proper due diligence to where to find them. By the way, the plaintiff wrongly suggests in its brief, so I would invite the court not to be misled on this point, because it is a red herring, that because there's a so-called occupancy and notice clauses in the mortgage, that Myra waived her right to be served at her residence in Michigan. Those clauses only apply to borrowers as defined in the note, and Myra was not a borrower. She simply signed the mortgage as Howard's wife. He was a co-owner, so she had to sign the mortgage to release her dower. She never signed the promissory note, so there's no issue here whatsoever. She's not a borrower. So the rules of civil procedure apply to her. So they have to find out. The duty's on the plaintiff, as in any case, to find out where the defendant resides. And Myra, they relied on this occupancy clause, which does not apply to Myra. It applied to Howard. He was a borrower. Didn't apply to Myra. So I don't think, I would respectfully suggest to your honors that there's no question there was not proper service. The only real question in this case, your honors, I would suggest, is that of standing. And going to Judge Carr's question, we have demonstrated an interest. The law is that that, you know, by virtue of her dower interest, which, by the way, the plaintiff deceptively suggests in his brief that having only a dower interest, Myra didn't even have to be named in the complaint. That's not correct. That's not in fact, I believe it was this court's. No, it was not this court's. I deal with this in the reply brief on page 4, Jackson versus Oasis. That was a situation where the wife, the husband signed off on signed a mortgage, and then he got married. So the dower interest was already released to the mortgagee by the time the marriage occurred. That's Jackson versus Oasis, cited on page 4 of my brief. So please don't be misled that with the argument that Mrs. Capone didn't even need to be named. She had to be named.
Counsel,
Okay?
I just want to let you know you're in your rebuttal time. You're welcome to
Okay.
continue, but I just wanted to let you know.
No, I'll defer. Thank you.
All right. Hang on 1 minute before you begin, please.
Okay, I made it back in. Sorry, I don't know what happened.
Okay,
You hear me?
thank you. Yes.
No idea what happened.
Welcome back.
Okay, just for the record, I know that Judge Schaefer was not visible there. The wonders of technology, sometimes wonderful, sometimes not so much. I think we can all assure you that for the portion of your argument that she missed, she is able to and will access that. Sometimes I'm not sure if I just don't see her, but she can still hear, but I guess that wasn't the case here. She's with us now. Mr. Dayton, you can go ahead and proceed. Unmute. There you go.
All right. Thank you, Your Honors. If it pleases the court, my name is Eric T. Dayton. I represent the plaintiff, Applee Chemical Bank, successor by merger to Talmer Bank and Trust. I'd like to, first, there was a reference in Mr. Moguki's argument to a reply brief that he filed. It's my understanding that that reply brief had been stricken by the court and that it's not currently before the court as it was not properly refiled. Additionally, Mr. Moguki indicates, well, he admits actually, both in his brief and in his argument, that a deed has been filed in this case. And as such, because a deed has been filed in this case, we are no longer dealing with a live controversy. This court decided in 2019 in the case of MTGLQ Investors LP versus Wagner that appellate courts will not review questions that do not involve live controversies. And it also determined in that case that both standing and jurisdictional claims are not exempt from that rule. Because the deed has been filed and because Ohio Revised Code 5721.39 makes clear that once a deed is filed, the title to the parcel is incontestable in the purchaser and is free and clear of all liens and encumbrances, we no longer have a live controversy before this court. Additionally, opposing counsel makes the argument that if service was not proper on Myra Capone, that the entire judgment entry of foreclosure is somehow void ab initio. Well, that's not the case. The only thing that would be void would be any judgment rendered against Myra Capone. And the only judgment rendered against Myra Capone was a purely in rem, not personal judgment, an in rem judgment extinguishing her dower interest. A dower interest which she had already relinquished by signing the mortgage. Judge Carr had a very good question. What impact has been made by the in rem judgment against Myra Capone extinguishing her dower interest? What impact has that judgment had on Mr. McGookie's client, Howard Capone? I would argue that no impact at all has been rendered by that decision. Again, Howard, Mr. McGookie's client Howard, is the son of Myra Capone. Myra Capone only had a dower interest, and that dower interest was both released in the mortgage and extinguished in this action. But had that dower interest not been extinguished in this action, what would have happened is she would have had a right to collect money from the surplus proceeds, if any, from the sale of this foreclosure action. But in reality, there were no surplus sale proceeds. The court need only look at trial document 133, the confirmation of sale, to see that there were no surplus proceeds. As such, it's irrelevant whether Ms. Capone's interest was extinguished through this action or not, because that interest would have attached to surplus proceeds, which there are no surplus proceeds. Judge Callahan asked a very good question of Mr. McGookie as well. She asked, how is the bank to know that Myra Capone's residence was in Michigan? In fact, the bank had no way of knowing. Instead, the bank was assured through its mortgage that Ms. Capone resides at the property, the subject property. The court should note that Ms. Capone, Myra Capone herself, has only made one statement in this case. There's no affidavit of Ms. Capone. There's no other pleading filed by Ms. Capone. The only statement made in her case is her signature upon the mortgage. And in signing the mortgage, she has certified that she is going to occupy the subject premises. Now, Mr. McGookie has stated that the evidence before the court indicates that she never occupied the premises, but that's not true. There is no evidence. There is no testimony of any party stating that she never lived at the premises. Instead, there is an affidavit filed by a Miss Miller, and that affidavit states two dates, both of which dates are after Myra Capone was served in this case. May 10th, 2018 is when Ms. Miller testifies that she became the guardian of Myra Capone. In September 19, 2017 is when she says that Myra started living in Michigan. Well, both of those dates are after the dates of service in this case. PD 27, trial document 27, is when resident service was made on Myra Capone, and TD 30 is when certified mail service was made on Myra Capone. Both of those types of service are sufficient to give the trial court personal jurisdiction in order to render a personal judgment against Myra Capone. But a personal judgment is not necessary in this case. Instead, we only need an in rem judgment in order to extinguish her interest, which is a dower interest, which she already released in the mortgage.
Mr. Dayton, I don't
Yes.
want to stop your train of thought, but could you hold on until Mr. Maguki joins us again?
I'm sorry. Sorry, Your Honor.
All right, go ahead, sir.
I believe I was saying that the only type of service that was needed against Myra Capone is in rem, because no personal money judgment was sought against her. And in fact, at trial document 108, even if this court were to find that all other types of service failed, which they did not, service by publication was made against the heirs of Howard. Myra, being the wife of Howard, is clearly one of those heirs. So even if this court were to determine that both residence and certified mail service failed, and I believe that those are unwarranted conclusions, there's no argument that service by publication was proper.
Isn't Myra Robert's wife? Isn't Myra Howard's mother?
Myra is Howard's mother. That is correct. I misspoke. Service by publication was made on the heirs of Robert. Robert died during this case. Once he died, we joined the heirs of Robert and served them by publication. And there has been no contesting that service was in any way irregular or improper. So I believe that there are no live controversies involved in this case. I think it's clear that Howard Capone does not have standing to challenge the service on Myra Capone. But even if both of those arguments are not found to be good arguments by the court, I think that the court needs to look at the actual service made upon Myra Capone. TD 27, trial document 27, you have residence service. TD 30, you have certified mail service. And TD 108, you have service by publication. There was an attempt to rebut the rebuttable presumption of service made in this case. But to the extent that a trial court has discretion to assess both the competency and credibility of the evidence of non-service, according to this 9th District Court's decision in Talarak versus Miles, the trial court clearly did not abuse its discretion in determining that Howard Capone, who admittedly is brain damaged so severely that his live-in girlfriend has to handle his mail and his finances, is not a competent witness, and that Anita Miller, who became a guardian after service was made in this case and only testifies about activities that took place after the service was made in this case, and bases her testimony not upon personal knowledge, but upon secondhand or third-hand knowledge that she ascertained in talking to her attorney. The trial court didn't abuse its discretion in determining that she is not a credible witness with regards to any evidence of non-service. I'd like to take any questions that you may have at this point. If there are no questions, I thank you for your time, and I believe that my arguments are more fully established and quoted in the brief I filed. Thank you, Your Honors.
Thank
Okay,
you.
Okay, thank you. Thank you again, Your Honors. The reason, Your Honor, Judge Callahan, I stepped off the screen for a minute was to get a copy of the docket of this case, because what Mr. Dayton said, and I have no doubt that what he said was true, was that my reply brief was stricken. And I'm here to tell you, and I will document this with an affidavit, I never received a copy of that order, which was a magistrate's order of September 1st. I would ask the court the leave to file the reply brief, which I'll have to check the local rule 7 that I did not comply with. Obviously, I didn't do that, but I did not receive a copy of that order, and so that's why the reason I stepped up to get a copy of the docket sheet of this case, because that comes as a complete surprise to me. But having said that, again, Mr. Dayton goes back to several issues which are totally debunked in the reply brief. He goes back to the argument of a live controversy and the case of MTGLO, I believe, which he cites, Investors versus Wagner, says that once the parties have been, the rights of the parties have been extinguished through the legal process, then the argument of mootness can set in, but only until the rights of the parties have been extinguished through the legal process can that happen. So that is a twisting and a contorting of the ruling of the case, and quite frankly would be a denial of due process if you could say somebody who has the right to service doesn't have to be served, because now that the case is over and the property's been sold, that person's rights are extinguished and it's all moot. That's not the law. That would be a violation of the 14th Amendment. The other thing he continues to argue, despite the in fact, the MTGLO is from this court, 2019 Ohio 1741. That's this court's 9th District's decision, and it actually cited by the plaintiff, but it works in the defendant's favor. It's exactly our point. And as far as permissive joinder, that's not applicable here. The case of Jackson versus Myasis, which again I believe was cited by Mr. Dayton, works in our favor. That's 2017 Ohio 1000 11th District. That's the case I referred to before, where the husband signed the mortgage before the marriage. Then, under those circumstances, that dower interest is already gone. So that case reinforces our argument. Just in conclusion, Your Honors, I would suggest to you this. There is no question, I can honestly say this to you, if you look at this case carefully, and I know you will, there's no question that the court erred in finding service. There's no question, not 1% question. There was no service. So the only real question, Your Honors, I would submit to you that you need to decide is whether Howard Capone has standing. And as I argued in my appellate brief, under Ohio law, he has standing because he's an heir at law of his mother, Myra Capone. Now, Mr. Capone is deceased. So when Myra passes, her interest, albeit dower, but that doesn't make it any less of an interest. It's a protectable interest under the U.S. Constitution. That will go to Howard. So Howard has standing. Howard has standing to make Myra's argument. I feel that very strongly about that argument too.
But she's still alive, so she's not. He's not an heir at law.
Hang on just a second. You're out of time. I'm not sure that you understood that Judge Schaefer's question. So if you want to ask it again, and you can answer her question.
It was just simply that Myra is still alive, so he's not an heir.
I'm sorry, Your Honor, I didn't hear you.
His mother's still alive, so he's not. He has no. I mean, there's no estate. He's not an heir at this point.
His mother is alive, true, Your Honor, but he has, I would suggest under the law, he has a protectable interest for purposes of service, this case. I would suggest to you, Your Honor, that he does have an interest by virtue of an expectancy. Okay, and that's all it takes is a sliver of an interest. I will just say in conclusion that Mr. Dayton's attempt, albeit superficially maybe attractive, that this is only quote a dour interest. That's not the law. I don't care whether it's a dour interest or it's a full-fledged half interest, tenant in common or interest in common, but it's still a protectable interest under the U.S. Constitution, and she had the right to be served, and by virtue of his expectancy, he has the right to raise the issue. There's our case in a nutshell. I appreciate
Thank
it.
you.
And by the way, Your Honors, if you feel it necessary, I will be happy to supply the court with an affidavit attesting, and I'm not going to put my law license on the line for anything after 41 years. I will attest to this court, if this court feels necessary, that I did not receive the court's order of September 1st.
All right, thank you
I
both
believe it
for
was a
your,
magistrate's order.
thank you both
Thank
for
you.
your arguments. We'll take the matter under advisement. Issue a decision or decisions in due course. It will be mailed to both sides as well as posted on our website and on the website of the Supreme Court. You both have a good day, and I'll just announce for anyone who might be interested, the court will next have video oral arguments on December the 1st.